Committee on Government Operations will come to order. Will the clerk please take the roll?
Chair Liberati.
Here.
Representative Spahutsky. Here. McFall.
Here.
Posthumus.
Here.
Green. Mr. Chair, you have 4 members present. You have a quorum.
Representative McFall moves to approve the minutes of the November 13th, 2024 meeting. Hearing no objections, they are approved. First up, we're going to have testimony on House Bills 6034 and 6035. Representatives Paez and Glanville.
Thank you, Mr. Chair and committee members. Just for the record, again, I'm Representative Veronica Paez, House District 11, east side of Detroit, Harper Woods, and St. Clair Shores. So I want to thank you all for the opportunity to speak with you today. As you're aware, there's 2 bills to this package, 6034, 6035. They are exactly the same, except that 6035 addresses district libraries. So I also want to clarify that these bills pertain to city, township, village libraries, district libraries, and that they do not address school libraries. So the purpose of this legislation is to safeguard the autonomies of libraries and their town or district residents, as well as hold harmless librarians and library staff. These bills also aim to ensure the same protections in the Elliott Larson Civil Rights Act, as well as our First Amendment rights to free speech. Libraries were established as archives and protectors of documents and culturally significant materials, including history. These bills also guarantee the public's right to accessible information. These bills aim to protect the rights of all Michiganders. I know this is short. Representative Glanville will be expounding on this as well as some others. I do have to leave for committee in a few moments, but I am very willing to take a few questions before I leave. Any questions? No? Okay. Well, thank you so much for your consideration of these bills. Just as an extra thing, these were really written with the mindset of being nonpartisan and helping all Michiganders, offering everyone the same protections, whether you are right-leaning, left-leaning, middle-leaning, however, there are protections for everyone. So I thank you again for your time. Thank you, Carol.
Thank you, Rep. Paez. It's been a pleasure to work with you on this package. Good morning, Chair Liberati, members of the committee. Thank you so much for the opportunity to speak with you today on behalf of a cause that is near and dear to many folks, I believe, and that is the preservation and protection of our public libraries. You know, public libraries are the heart of our communities. They provide access to knowledge, resources, and opportunity for everyone. They empower small businesses. I know myself, when I've been engaged as a consultant, you know, a lot of times we start our small businesses in our libraries because that's where you can get a little bit of office space, a little bit of Zoom space, and maybe even as elected officials, we've taken advantage of that from time to time during our in-district periods. Libraries also help parents support their children's education. And they offer space to all for lifelong learning. Enhancing local control of libraries by setting guidelines for out-of-district requests. This ensures that libraries can continue to prioritize the needs of their local patrons. Local control ensures that our libraries remain flexible, community-oriented, and in tune with the needs of the people that they serve. But above all, this bill is about more than books and programs. It's about protecting the very essence of what libraries represent: freedom, opportunity, and community. Libraries are spaces where individuals are free to explore ideas, to learn, and to connect with others on both common and new interests. They offer a sanctuary from the pressures of daily life. They are a place of pursuit for knowledge that is valued above all else. By protecting our libraries, we are not just preserving physical spaces or collections of books. We are safeguarding the values that unite us as a community and as a society. So with that, I do urge this committee to support the important work of our libraries by voting yes on these bills. that will protect local control in our libraries by establishing clear standards and processes for selecting and withdrawing materials from collections. By protecting our libraries, we're not just preserving those books. We are supporting freedom, community, and the values, again, that unite us. Thank you for your consideration.
No questions.
All right.
Next up, we'll have Kyle Zawicki from the American Civil Liberties Union. We got a lot of people speaking. If you can keep it around 3 minutes, that'd be great.
Thank you, Chair Liberati, Vice Chairs, and members of the House Government Operations Committee. My name is Kyle Zawicki, and I am the Legislative Director for the American Civil Liberties Union. For more than 100 years, the mission of the ACLU has been to realize the promise of the Bill of Rights for all, with a commitment to protecting and expanding the freedoms guaranteed under the First Amendment, especially the freedom of speech. When free speech is valued, environments are needed to safeguard diverse ideas. Libraries are the critical spaces to house these freedoms. Libraries provide the public with access to knowledge, a forum for exploring diverse perspectives, opportunities to engage with the world's vast array of ideas, some of which may challenge or expand individual beliefs. House Bills 6034 and 6035 ensure that public and district libraries remain true to that mission. By granting library directors or their chief executives authority over the selection, inclusion, and withdrawal of materials, these bills safeguard professional expertise in maintaining diverse and inclusive collections. Importantly, the bills prohibit the removal of materials based on religion, race, gender, sexual orientation, or other personal characteristics of the author, or the content's viewpoint, ensuring that personal biases and ideological pressures do not erode the public's access to information. This approach was not only a reflection of the First Amendment values, but also aligns with Michigan's constitutional mandate under Article 8, Section 9, which requires the legislature to provide for the establishment and support of public libraries which shall be available to all residents of the state, regardless of their background or beliefs. These bills affirm the legislature's responsibilities to preserve libraries as equitable and accessible spaces for all Michiganders. In addressing the concerns about the potential of inclusion of inappropriate materials, the bills responsibly address this by limiting reconsideration of materials to those adjudicated as obscene or otherwise unprotected by the First Amendment. This ensures that library collections remain free of illegal content while protecting them from subjective judgments about what is considered offensive or disagreeable. As states nationwide grapple with the challenges to intellectual freedom and efforts to censor library materials, Michigan has an opportunity to lead by example. House Bills 6034 and 6035 establish a framework that respects professional librarians' expertise, protects intellectual freedoms, and affirms the right of every individual to access a diverse range of ideas. These principles are the foundation of our democracy, and the ACLU of Michigan urges your support of House Bills 6034 and 6035. Thank you.
No questions.
Thank you.
Next up, we'll have Debbie McCula from the Michigan Library Association. Oh, you got written, okay. Next up, we'll have Jenny Marr from MLA CADL.
There, thank you, appreciate it. Thank you again for your time today. My name is Jenny Marr. I'm the Executive Director of the Capillary District Libraries. I was previously at the Ferndale Library. I'm also the President-elect of Michigan Library Association and Chair of the Advocacy and Legislative Committee. I'd like to talk about what these bills can do to help libraries from an operations standpoint. All libraries serve their local communities. We're responsive to their ever-changing needs, and we're committed to providing a wide range of materials, services, and programs to everyone in the community. If our residents want to have a conversation about those things with us, then we're happy to engage in that dialogue. We are guided by locally appointed or elected library boards who determine policy and who hire a director to implement those policies. These bills create a framework allowing us to do that work on a local basis. They aren't about specific titles. They are about having policies and rules in place to focus our time and energy. We don't have a problem with having meaningful discussions about our collections. What makes our jobs difficult is the constant inundation of requests on the same titles, and often from people who don't live in our community. Haven't actually looked at the book, but for their own reasons are trying to engage in cancellation and censorship. I want to be clear that this isn't limited to one side politically. We have activists from the full ideological spectrum who try to limit what information is available to those who don't agree with them. Libraries stand firm against censorship of all kinds. We will protect everyone's right to access information. We often say that if we've done our job well, then we've got something to offend everybody in the library. The First Amendment means that all patrons of a library have an equal opportunity to choose or not choose items on the shelves. Every family has their own story, their own traditions, their own beliefs, and we defend the rights of parents to make those choices for their children. Freedom and democracy take work. In order to preserve the rights of your own family, you need to be willing to defend the rights of other families too. These bills do not close down the ability to request reconsideration of materials at a library, but they instead limit it to the local communities. The language mirrors existing state law. Libraries take every request seriously, and we spend hours on thoughtful review and responses. But we're also public employees, and being inundated with redundant or outside requests is a waste of public resources. We want to focus our time and energy on our local community, and we are asking that you support these bills to protect our work and the rights of all the people in Michigan. Thank you for your time.
Thank you. Next up, we have Brian Cloutier from Oxford Public Library.
Good afternoon. Representatives, I am Brian Cloutier, Director and CEO of Oxford Public Library. I firmly believe in treating everyone with dignity and respect regardless of their race, ethnicity, gender, or orientation. I have an expectation that my team do the same, and I stand behind my assertion that my colleagues adhere to this ideology as well. And yes, I hold my elected officials to the same standard, even though some of them have clearly forgotten what this looks like. These principles are simple. They are non-political, unbiased, and formulate a very important basis for which we foster a healthy organizational culture in libraries today. I'm a moderately conservative Republican. I share this with you not because it is relevant to my role as a library director, but rather because it has become a crucial part of the dialogue we have been forced into having with our communities when defending intellectual freedom and upholding our constitutional rights. I believe that public libraries should be unilaterally representative and reflective of their communities, and that the collections they house support inclusivity among the people they employ and the citizens whom they serve. Compassion, sensitivity, and yes, even accountability is an equal part of this pledge we make together. For 30 years, I've had the honor of serving a handful of communities, each consisting of varying ethnic diversities and socioeconomic makeup. A commonality among them, and in Lapeer, where I reside, is that conservative viewpoints and values influence just about all of the public offices held by a majority of the elected officials. This by itself is not a problem. We have the right to elect who we want to represent us in local, state, and federal offices. However, when our elected officials are no longer capable of serving without bias and use their elected offices to assert pressure and intimidation, it becomes a serious and systemic threat to our individual freedoms. It is appalling to me that a county prosecutor can be allowed to even use his political office to intimidate a library director. This cannot happen. The Lapeer County prosecutor, after inciting public unrest, was forced to retract more than one of his inflammatory statements documented in local newspapers that were made against the library director. Moreover, he used resources afforded him by his public office to threaten legal action against the director personally, not excluding having her arrested if she failed to remove a book from the library's collection. HB 6034 and 6035 can provide critical protections that help prevent these types of baseless threats from continuing. They will not change the fact that we've already lost a great library leader who decided to walk away from her passion and position because of relentless threats against her, not to mention the slanderous, defamatory, and hurtful words that were said about her staff as well. My hope is that these bills will help prevent other librarians from being subjected to the same level of hateful and dangerous rhetoric in the future. Good library policy, along with supportive legislation, play equal parts in reinforcing organizational standards and benchmarks that uphold fair and equitable access to library collections and services. Library administrators, myself included, spend countless hours responding to book challenges, more times than not by individuals who live outside of our taxing jurisdictions. Do I believe that some of my colleagues sometimes push the envelope of what is, in my opinion, using good judgment when developing their collections? Perhaps. Does that give us the right to use dangerous, unfounded claims and ineffectual rhetoric in responding to that assumption? Absolutely not. One thing is unequivocally certain here. Librarians do not wake up in the morning and go to work to groom children. Instead, we defend their rights and the rights of their parents to unobstructed access to sometimes critical information. I encourage my fellow conservatives to put partisan politics aside and to come together with friends on the other side of this issue to do what is right. Join me in defending intellectual freedom. Join me in protecting constitutional rights, and join me in supporting these bills to become law. Freedom of speech is not solely belonging to a Republican nor a Democrat. It is a fundamental right we are all empowered with and entitled to as citizens of the United States of America. In the words of Laura Bush, who happens to be a Republican and a librarian, quote, "Libraries allow children to ask questions about the world and find the answers. And the wonderful thing is that once a child learns to use the library, the doors to learning are always open," end quote. Think about the power of this statement, and think about the power the public library has in providing access to a constantly evolving worldview. The root cause of this problem stems from a society where parents today simply need to learn how to be parents. It's not the librarian's job to act in their absence, nor does the law even allow us to do so.
I'm sorry, we're under a time crunch. Can you
I'm done
wrap
in a
it up?
minute.
All right.
I have a very straightforward approach to this issue. When parents play an active role in assisting their own children selecting books from the public library versus focusing on their own energy on what other parents' children can check out from the library, everyone wins. In closing, November 30 marked the anniversary of the tragic shooting that claimed 4 innocent lives in Oxford, a community I've served for the last 18 years. From my perspective, we have much more serious issues to overcome, yet we sit here today debating which title should or should not be allowed in the public library's collection. Something's seriously wrong with our priorities.
No questions. Next up, we're going to be taking testimony on Senate Bill 493. Here from Senator Santana's office is Dr. Raphael Johnson.
Good afternoon. My name is Dr. Raphael Johnson. I serve as Legislative Director in the Michigan Senate in the office of Senator Santana, and it's on behalf of the Senator that we would like to thank you for the opportunity to speak on behalf of Senate Bill 493. Here with me to my left, we have the current Legislative Corrections Ombudsman, Mr. Keith Barber, and we were going to hear from Mr. Walter Miller, a justice-involved citizen who will share his lived experience with prison gerrymandering practices. Lastly, for the sake of time, we have the Indiana Corrections Ombudsman, Mr. Terry Schuster, who will be testifying via Zoom. According to testimony before the Senate Committee on Oversight, the state of Michigan paid $42 million in lawsuits in 2021, with half of the money going to 100 cases paid through the Michigan Department of Corrections for judgments. Members of the legislature are tasked with overseeing departments and have cited that certain data is often not available to them. Some believe there are systemic issues within corrections facilities within the state. It should be noted that once a plaintiff successfully navigates the summary judgment stage of a case, the MDOC almost never proceed to trial, but instead opt to settle the case. Subsequently, all the details of alleged violations of constitutional rights, state laws, policies, and procedures are never heard nor made a matter of public record for reporting purposes. Accordingly, it has been suggested that reporting requirements be increased to promote transparency and accountability within the Legislative Correction Ombudsman's office. Senate Bill 493 will play a crucial role in ensuring that Michigan's correction systems operates fairly, effectively, and humanely. I will now turn it over to LCO Mr. Keith Barber, who will outline some of the addendums of 493. Thank you.
Thank you. Good afternoon, representatives. So my name's Keith Barber. I am the Legislative Corrections Ombudsman. And the major changes in this bill to our statute right now would be primarily to rename the office from Ombudsman to Ombudsperson. That's a trend that has been going on nationally with various state and local ombuds offices, and we're coming in line with that whole naming process. It would expand the list of individuals to make a complaint to our office. Right now, prisoners and legislators are the only named people. We have a caveat in statute that allows us to take things on our own initiative, where we've always talked to family and the incarcerated population and advocacy communities, but this would identify them statutorily as complainants who could reach out to us for investigations. It would also require us to have develop a standardized complaint form, make that available online and in our correctional facilities, so it's available to both family members and the incarcerated populations. We already have that developed, but we just need to expand that so it's more available. It will allow us to consult with or contract with qualified experts, which is defined in the bill. That would allow us additional assistance to conduct our investigations and to provide the legislature with some independent information on a number of things that are being tested that we get complaints about and have historically for years. This would require us also to give the department 72-hour notice if we intend on taking an expert in. We would provide specific information about the expert, their credentials, and give the department an opportunity to vet that individual. It would prescribe specific timelines regarding the release of recommendations we make. Right now, we are required to give the department an opportunity to respond if we're making a recommendation or publicizing something that's critical of the department or a person within the department. This puts a time limit on it where they would need to respond to us within 30 days. They could request one extension of 14 days with that, according to the bill. It would also require the department to notify us within 30 days of any action they take on recommendations that we make. Right now, there's no requirement for any notification, and we often don't get that. We are required to do an annual report for the Legislative Council, which we do. This would expand that. It would make our report available on our website. It would also expand some of the things or codify what we report. That would include the numbers of complaints, the types of complaints by correctional facility, and then whether or not they were denied, we denied them, if we resolved the complaint, if they were unsubstantiated, what our finding was essentially. Those would all be posted in our annual report and would be required to be posted on our website on a monthly basis as well. That's really the extent of the changes in this, and I'd be happy to answer any questions you may have.
No questions.
Sounds good. Terry Schuster, who's going to be visiting us via Zoom, is actually the New Jersey Ombudsperson, not Indiana.
Okay. Somebody gave me the wrong information.
But, they are. Anyway, just thought I'd clarify.
Good afternoon. My name is Walter Miller. I am formerly incarcerated. I went to prison when I was 17 years old, served 33 years in the Michigan Department of Corrections. Throughout my time inside the MDOC, I served as a jailhouse lawyer, the Department of Corrections certified prison legal writer, and as a prisoner representative on wardens' forums at various facilities. Throughout my time, I was transferred 35 times to 23 different correctional facilities for lodging complaints about the conditions within the correctional facilities I was at. The question I have to each one of you is, can you imagine having a job where you answer to nobody? The MDOC director is the only state director who has nobody to answer to, except for the governor. The power of this body is limited under state law. The Michigan Supreme Court in the case Blank versus MDOC stated that you ceded your authority over the Department of Corrections through MCLA 791.206. That gives a director authority for the management, operation, and pretty much everything within correctional facilities. I was a party to a lawsuit back in the 90s when they changed the visiting rules. And we argued that the Joint Committee on Administrative Rules had authority as checks and balances to rules being implemented. The court said no, that the MDOC director could write any administrative rule they wanted to. So the rules that had been promulgated by this body over the years were all rescinded by various MDOC directors. We have a state where there's not one accredited correctional facility. The University of Michigan is accredited. Michigan State University is accredited. There's no MDOC facilities that are accredited. You can go on the American Correctional Association's website, enter any prison in the state of Michigan into their site, there's no accreditation. Who does oversight? Who has the ability to say what you're doing is wrong? The court's ability to step in is limited. The Michigan State Police has a policy that unless the DOC calls them, they will not investigate. So if you have a family member who's subject to an abuse, an assault, you can't call the state police and have them look into it. They expect the MDOC to do so. I always enjoy when I come to these hearings and hear the MDOC speak. They speak a different language than each one of you. And their language is one of, let's cover up what's going on. Let's tell them what they want to hear, because we need them to continue to fund us. When I went to prison in 1986, the MDOC budget was roughly $800 million. Today it's over $2 billion. They have less facilities, less prisoners, but still the same amount of money. People who are qualified for jobs within the prisons can't get those jobs because they have felony convictions. I testified earlier this year at a Senate hearing regarding prison gerrymandering. I was housed in a facility in Luce County. Senator McBroom really didn't like what I had to say. I like him, though. I want to meet him. The situation was, they called me up, tell me to take the census. I explained to them, I'm not from Luce County, I'm from Wayne County. So why would I take a census in Luce County when I'm from Wayne County? Oh, it doesn't matter, it's no big deal. They didn't understand that due to my time in law library and studying law, studying policy, they understood exactly what was going on. And as a result, I was transferred. They was like, get him out of here. That is a big problem. I understand you Upper Peninsula facilities are suffering, but it's not the result of the prisoners. It's the result of decisions made by the MDOC. Prisoner visiting affected those communities. They convinced them to build these prisons with the understanding that you could build hotels, you could build restaurants, you could build gas stations, because people gonna come. When the DOC changed the visiting rules in '95, those communities lost revenue and income, and it's never been replaced. So now they look to you to figure out, well, how do we fix this? I mean, I have a lot more that I could say, but I know time is limited. Anybody get any questions? I'm pretty much a history book of the MDOC for the last 40 years. I can tell you anything you want to know about anybody in the MDOC because they pretty much raised me. You're looking at a product of the Michigan Department of Corrections. And I've been successful in spite of them, not because of them.
Thank you for your testimony.
I was hoping somebody would ask the question. And Kyle, he's a good guy, but he's going to come out with the money.
So now we'll turn it over to Mr. Schuster, who is the New Jersey Ombudsman right now.
Hey, can everybody hear me okay?
Yes.
Hi. My name is Terry Schuster. I'm the Corrections Ombudsperson for the state of New Jersey. I have authority to do independent prison oversight statewide. I just wanted to testify about one piece of this bill about retaining expert consultants and contractors and bringing them in on occasion to do a prison site visit. There's nothing in this bill that's out of the ordinary. There's nothing in this bill that's unsafe. There's nothing in this bill that's extreme. This is a really standard thing that that is an authority for similar offices in other states. And for good reason. There are only so many people on my staff, and we have the expertise that we have, but it's not, we're not experts in all things. So, for example, when somebody points to the ceiling and says, those spots up there, that's black mold, I can look at it and I can speculate, but I'm not an expert in black mold, and it's easy enough for me to just grab an expert, bring them in, they can test it and they can bring it, send it off to the lab, and they can have, then have an independent assessment of whether or not it's mold. Or we had a similar situation where people at one facility were complaining of discolored and cloudy water, and they didn't trust when the Department of Corrections said, it's fine to drink the water, we've had it tested. And so my office was able to do an independent assessment and then back the department up and say, we tested the water too, and it is okay to drink this water. And people were willing to hear it from us, even when they weren't willing to hear it from the Department of Corrections. There are other examples where, I'll bring in a nursing consultant to look at how bandages are attached for wound care, and just to sort of give an independent assessment of is this appropriate? Because our office would get complaints and I'm not an expert in that. So we'd have a nursing consultant look at that. We would get complaints about the evacuation plan for people in wheelchairs if there's a fire in a particular prison. And so we went to a prison where the elevator wasn't working, and the evacuation plan involved bringing people who are in wheelchairs down the stairs. This is something that I'm not an expert in, but I was able to get, without paying for it, able to get sort of a nonprofit attorney who focuses on disability access to, lay her eyes on it and give her own assessment. And similarly, if there's a complaint about disability access within somebody's prison cell, within their room, sometimes you can just describe it to an expert or take a photo and bring it to an expert. And sometimes that expert really needs to see it for themselves. And so what the bill does here is sort of allow the ombudsperson to take that expert and use the ombudsperson's access and say, I'm going to bring you in just, with an escort. There's nothing unsecure about it. This person's going to be background checked. Any materials they bring in will be searched for contraband. And then they're going to be able to see for themselves and then offer an expert opinion. I think this is a good thing. I think it's a very normal and standard thing, and just wanted to share that as you all consider the bill. Thanks for having me.
No questions. Thanks for your testimony. Nobody wants to ask questions today. Next up, wishing to speak in support of the bill, Barbara Opewal.
Okay, my name's Barbara Opewal. Thank you for letting me speak to you today. I'll try and keep my comments brief. I am speaking as a family member of a person, my son, that was held at Oakland County Jail. Now, unfortunately, he did not make it to the state prison system because he committed suicide in his solitary confinement cell at the county jail. Now, why is this bill important? Because it gives family a chance to speak and file a complaint. Why is that important? because oftentimes inmates lose their communication privileges. In my son's case, all of his privileges were taken away for the 30 days prior to his death. That means no phone calls, no messaging, no photos, no visits. Okay, so why is this bill important? Because it gives me a way to escalate a grievance if the grievance is not heard or resolved within the facility. So in my son's case, he and other inmates had filed a grievance that their walk time, which is supposed to be 1 hour out of 24 hours, and in that walk time, they're supposed to be able to take a shower, walk around a corridor, make a phone call. Their walk times were being reduced and denied. They filed a grievance. That grievance was dismissed. It was dismissed on the basis that there was no body cam footage, which means the deputies in charge of those walks can turn on those body cams and turn them off at will. Now, what happened when that grievance was dismissed? Did anyone take the time to go and look at the logs of the prisoners making the grievance? No, no one looked. Because if they had looked, they would have seen that in my son's case, there was a period of 13 days with no walk, a period of 8 days with no walk, 5 periods of 4 days where he was not let out of a 5x8 cell to take a shower, make a phone call, or walk around an internal corridor. So yes, he did kill himself. And if you don't think these things are happening in your state prisons, they're happening every day. Terrible civil rights, human rights, American with disability rights are being ignored. So please, pass this bill. Give some oversight, give some transparency, collect some data so you know what's going on. Protect these people. They are citizens. They paid taxes. They voted. You know what? Their rights need to be protected, and it's your job to protect them. Thank you.
Thank you for your testimony. Next up, we have Luis Polano, Citizens for Prison Reform.
Hi there. I'm going to keep this very brief. I have submitted written testimony. I'm Lois Polano, Executive Director of Citizens for Prison Reform. We assist and support families who have loved ones that are incarcerated, and we now are also working on conditions and human rights violations inside of our prisons and inside of our jails. And if you look around today in this audience, you see so many families that have showed up and advocates who are here because they want to see transparency, accountability, and oversight within this system. We have waited a very long time for today to occur. We have fought long and hard since last February. We held listening sessions for House of Representative members. We had over 25 House members who joined our listening sessions. And what we heard from all of you is that this is a no-brainer, this is a common sense bill, but yet somehow politics was allowed to stop this bill from moving forward. I am here today asking all of you to lay those politics aside This is bipartisan. This is common sense. And we need to do the right thing on behalf of all of these families that are here and on behalf of all of the over 34,000 individuals who are sitting inside of our prisons. We need to pass this bill and move forward. We will be back working on transparency, accountability, and oversight in the coming year, and we hope that you will support our efforts. Thank you.
Thank you for your testimony. I have a few cards to read in. In support of the bill, not wishing to speak, Gabrielle Dressner, ACLU, Michigan. In support of the bill, not wishing to speak, Wanda Hollister. In support of the bill, not wishing to speak, E.B. Jordan, S&D PJ Housing. Not wishing to speak, in support of the bill, Rusty Merchant, FAMAM. And opposing the bill, not wishing to speak, Kyle Kaminsky, Michigan Department of Corrections. Representative Fall makes a motion to report Senate Bill 493 with recommendation. Will the clerk please take the roll?
On the motion to report, Chair Liberati.
Yes.
Representatives Putski.
Yes.
McFall.
Yes.
Posthumus.
Yes.
Green. Mr. Chair, you have 4 yeas, 0 nays, 0 pass. Senate Bill 493 is reported recommendation.
Next up, we're going to take testimony on House Bill 6166. It's Representative Carter, and joining him will be Claude Molinari from Visit Detroit.
Yeah, come
on. Thank you so much, sir.
Not a problem. Good.
When you're ready.
Still morning. No, it's afternoon.
It's afternoon.
Good afternoon. Thank you, Chair Liberati and members of the committee for allowing me today to testify on House Bill 6166. I'm joined today by Claude Molinari from Visit Detroit. Currently, Michigan's Convention and Tourism Marketing Act allows Visit Detroit, also known as the Detroit Metro Convention and Visitors Bureau, to levy an assessment of up to 2% on charges for rooms in hotels and motels with 35 or more guest rooms in Wayne, Oakland, and Macomb counties. The 2% assessment fee pays for the Bureau's marketing program, which promotes Metro Detroit area regionally, nationally, and internationally as a tourism destination. The assessment is not a tax. It is a source of funding for Visit Detroit. This legislation, House Bill 6166, will allow for the hotels to voluntarily increase their assessment to 3% immediately, as well as provide a path to increase the assessment to 4% in the following years. The assessment requires support by at least 50% of the hotels paying into Visit Detroit, requiring buy-in from hotels and motels in the region. As we know over the last few years, and this is the part that I like, as a born and raised proud Detroiter, has become an increasingly popular tourist destination and remains a major driver in Michigan's economy. As downtown Detroit and the metro area continues to grow and attract visitors from across the globe, expanding the efforts of the Visitors Bureau will greatly benefit the entire state of Michigan. I will say more, but I'll turn it over to Mr. Molinari so he can provide some statistics.
Thank you, sir. Chairman, good afternoon, Chairman Liberati and the esteemed members of the committee. Basically, if a hotel room costs $100, the end user pays $102. Those $2 come directly to Visit Detroit. 92% of the revenue we receive goes towards marketing the region. 8% goes to overhead. According to Tourism Economics, who did an assessment or did an unbiased study, the assessment increase will have no negative impact on hotel occupancy or room sales, but will increase tourism revenue to the area by $295 million over 5 years. The hotel owners are fully on board with this initiative and will propel Southeast Michigan further, as well as Detroit and the state of Michigan. We have the mayor, the 3 county executives also fully on board with this act. The more we market the destination, the more visitors we will attract, selling more hotel rooms, which will increase the assessment revenue, which means that we'll further increase our marketing efforts, which means that we'll further drive hotel occupancy and tourism to the region. Basically a virtuous circle that just keeps on going.
I just have one question. Does this come in line with other major cities?
We're
are most
well
people
below
doing
most
this?
other cities. Sorry to interrupt you, Mr. Chairman. Yeah, in the state of Michigan, every other bureau charges 5% assessment. We are at 2%. We're looking to go to 3% and then increase at stop at 4%. We feel that that's the appropriate space to be. But across, if I look at our competition, it's Cincinnati's at 4%. Chicago's at 4.5%. Columbus is at 6.5%. Out the door, we're cheaper. So what the end user pays, we're cheaper by almost $2 versus our nearest competition, which is Columbus, Ohio. So even after this bill were to go through, presumptuously, then we'd still be 59 cents cheaper than our nearest competition.
No other questions?
Well, since we have plenty of time and nobody's left, no, I would just like to say and Claude didn't talk about it, with the NFL draft, with the Lions winning, there's so much energy, and you cannot find, I remember years ago, church groups would have conventions downtown. They have to go to Southfield and other places now. I think we need to keep that energy, capture that energy, and this is not a tax. People want to come, and we should benefit from that. So thank you, committee.
Thank you. We got one card in support of the bill, not wishing to speak. John McNamara, Michigan Restaurant and Lodging Association. With that, Representative Pulaski makes a motion to report House Bill 6166 with recommendation. Will the clerk please call the roll?
On the motion to report, Chair Liberati.
Yes.
Representative Pulaski. Yes. McFall.
Yes.
Posthumus.
Pass.
History of 3 yeas, 0 nays, 1 pass. House Bill 6166 is reported for recommendation.
Representative Posthumus moves to excuse absent members. There being no objection, the motion prevails. And there being no further business before the committee will stand adjourned.